Excited about that. We're getting some more folks. Oh, we're live. All right, I gotcha. So hello, everyone. Hello and welcome. Welcome to another episode of the Empowered Immigrant Live. So happy to be with you here today. I'm having a great day today. Oh, wait, I got to go live on Instagram too. All this like setup. Oh my gosh. I was telling Danitza is on our team. She's in Mexico, and she's amazing. And she like helps us set all this stuff up. But she was gone last week. So if you were on our live session last week, there might have been some technical challenges. And so anyway, Danitza, we're happy to have you back. We're happy to have you back. So hello, everybody. All right, and welcome to the Empowered Immigrant Live. Today, what are we talking about today? Today we're talking about green cards through VAWA. All right, green cards through VAWA in 2022. And so welcome YouTube, welcome Instagram, welcome TikTok, welcome Facebook, welcome everybody. All right, thank you all so much for being here. Remember, all right, at the Empowered Immigrant Live, we are here to train, to teach, to inspire, and to empower immigrants to make the most out of immigration laws and to make the most out of their lives. Today, our theme, all right, is everything that you need to know to apply for a green card based on VAWA in 2022. And so there's the question, right? Is it time for you? Is this year your year? Is it time for you to come out of the shadows? All right? Is it time for you to stop tolerating being in an abusive and harmful relationship? If so, hey, you might be eligible for VAWA. And if this year's your year, hey, let's do this. Let's do this. Let's go for it, people. Let's go for it. As always, thank you to everyone who asked your questions. We've got 30 minutes to discuss this topic in English, then we'll do it in Spanish. Si usted habla español, que venga con nosotros en 30 minutos, okay? And my name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. Today I'm talking about VAWA, VAWA-based green cards, and as always, to do that, we got to start with the basics, all right? We got to start with the basics, everybody. And before I do that, if you've submitted a question, if you've got a question, hey, send it my way. All right, put it in the chat, put it in the comments. All right, we'll do what we can to answer your questions here today. All right, VAWA. What is a VAWA case? All right, VAWA stands for the Violence Against Women Act. All right, this was an act. This was a law. It was passed in 1994. Originally, and modified several times, actually. It allows people, for immigration purposes, VAWA was actually a large act, but for immigration purposes, it allows people who are married to U.S. citizens or green card holders who are the victims of abuse, domestic violence, or quote-unquote extreme cruelty. All right, remember that. All right, abuse, domestic violence, or extreme cruelty. It allows these people to come forward and petition for their own green cards. They don't have to depend anymore on their abusive spouse to petition for their green card. They can petition for their green card on their own. We call it a VAWA self-petition, all right? Because people can petition for themselves. How cool is that? It empowers people to petition for themselves. Pretty good, all right, pretty good. It applies for both men and women, so don't be confused about Violence Against Women Act. The law works the same. It's, so if you're a man in an abusive relationship, you can qualify for this also. Doesn't matter the type of marriage. It could be same-sex marriage, opposite-sex marriage. That doesn't make any difference, all right? And so in order to qualify, you have to show, one, that your marriage between you and your spouse was, quote unquote, in good faith. It wasn't just for immigration purposes, all right? If you're breaking up, if you're divorcing, if you filed for divorce, all right, you have to file your case soon, your VAWA case soon. You have a 2-year time limit after a divorce to file a VAWA case, so that's something to note. The second requirement, you got to show that you actually resided together. You lived together, okay? The third requirement is that you were the victim of abuse, domestic violence, or extreme cruelty. All right? You don't have to have reported those things to the police. Sometimes we get that question, but we need to explain. We need to have clear evidence that shows how you suffered. And if there was abuse, physical abuse, that counts. Or also if there's extreme cruelty. So what's extreme cruelty, right? Well, extreme cruelty could be verbal abuse. It could be they wouldn't allow you to leave the house. All right, it could be like they were trying to control how you spent your time, or how you maybe controlled your finances. They wouldn't give you access to your bank account, or something like that. There's got to be some kind of like harm, right? Some kind of abuse, cruelty. Okay. And we can talk that through. Something like that is something we talk through in a consultation. The fourth requirement is that you have to be a person of quote-unquote good moral character. What does that mean? Basically means you can't have certain crimes, all right? You can't have caused certain problems. You can't have lied to immigration, right? In recent history. This doesn't go back forever. This goes back typically for the last 5 years, okay? And if you're seeking a green card through VAWA, which we'll talk about that in a moment, if you're seeking a green card through VAWA, you must also be admissible. Get it? So admissibility asks all kinds of things. If you have a quote-unquote permanent bar because of unlawful presence issues, you might not be eligible for a VAWA-based green card, okay? And if you've been deported in the past, things like that, there might be issues with getting a VAWA-based green card, but you might still be able to petition yourself. All right, so I want to do some nuance. I don't want to get too far into the weeds, but I do want to explain a couple nuances. One, you can start with a VAWA petition only and request a work authorization card through it to see how that goes, and then either later apply for a green card if you're eligible for it, and you can break up the process that way. Sometimes that's a wise thing to do if there's inadmissibility grounds, or if you might not be eligible for the green card for some reason, okay? Sometimes you can just do the petition and then renew it, okay? Just renew it, update your work authorization card, and we call it deferred action, through a VAWA self-petition. So that's possible, okay? Even if you're barred, for example, from a green card, you might still be eligible for some benefits through VAWA. The second thing that's kind of a nuance, right? There's friendship, there's synergy, there's similarities between VAWA and the Uvisa. You may have heard of the Uvisa. Here's the deal. If you called and cooperated with the police because of abuse that you suffered, right, you might also be eligible for a Uvisa. And sometimes there are strategies that Uvisas and VAWA might even be filed at the same time. We've done that before. It's perfectly okay to do that. Now, why might you do that? Well, you might get a work permit faster through VAWA, but maybe you can't adjust. Maybe you can't get your green card through VAWA. So maybe we can refresh your work permits through VAWA while you're waiting for a Uvisa. And then once your Uvisa is approved, you'll be able to get a green card through that, because the Uvisa comes with broader waivers. Okay? Anyway, talk to a lawyer who knows this stuff. If you are an immigrant, and if you potentially have a VAWA case, if you've been abused, all right, and if you've been married to a U.S. citizen or a green card holder, talk it over with a lawyer. You want to talk it over with a lawyer who knows this stuff, all right? And so, just that. Okay, the main thing about all this, right? The main thing, this is not immigration advice. This is human-to-human advice about VAWA. If you're being abused, if you're in a toxic relationship, if you're the subject of cruelty, right? Get out of that relationship. We just had Valentine's Day, man. Valentine's, like we should be in love. We should be in a happy and healthy and positive and an empowering relationship. If that's not the relationship you're in, get out of that relationship. Do not tolerate being in an abusive relationship ever, okay? And immigration law has the ability to help you. It allows you to petition for yourself without your spouse. Got it? Without your abusive spouse. You don't need to depend on that abusive relationship. Instead, depend on yourself. You're in control. You have the power. You have the rights. You have the law on your side. Maybe this is one of the few areas of immigration law where, yes, you have the law on your side. You've got to know that. You've got to understand it. And knowing that, I mean, knowing is half the battle, right? Knowing that, now you know, hey, reach out, talk to a lawyer, reach out, figure out, can you benefit from this law so you don't have to go back to your country if you don't want to, and so that you don't have to tolerate being in an abusive relationship even for another second. Get out of that thing. Okay? That's really it. That's really it. That's my talk for today. If you have questions, send them over. All right? If you have questions, send them over. I see one here. First of all, Top Drive 190. Hello on Instagram. Hello. Thanks for joining me here. All right. I see another question from, is it Moeen? Moeen. You say, hi, do you have any update about pending Asylum, who filed in 2017? Oh my gosh, Moeen, thank you. You are not alone. Asylum cases are pending. There is a backlog that is enormous, and the government's going through them, but it is a pretty sad sight for sure. There is no end to that tunnel, no light at the end of the tunnel in sight yet, all right, is the honest truth, because really there are so many cases in the backlog, and as you're aware, the regulations changed, all right? They changed in January 2018, where now they started doing last in, first out. So the last case filed was the first case that got adjudicated. So cases from 2017 are in a backlog that's enormous. And then you add the coronavirus pandemic to that, and now it's super crazy big. My next question here is from Wakar. Wakar, hello, you have a question about inadmissibility? I can see you there. Ask your question about inadmissibility. Bring it. I love it. All right, while he's doing that, I did get some other questions as well. None were VAWA related. Let me see if I can help them. There was a question from Melvin. Melvin, thank you for your question. It's not exactly, there might be other options that are not options through my firm, right? You say, my friend is an independent robot programmer, and while he was trying to enter the country from Brazil, he was refused entry at the airport and given a 5-year ticket. He was contracted with Tesla, and he needs to work. What options does he have? So interesting question. First of all, we want to either request FOIAs to see what exactly happened at the airport. We can request that, request the records to study them. That's first of all. Second of all, if he was given a document when he was refused entry, typically when they refuse entry like that, either they're suspicious that that was really why he was coming in, or maybe he had the wrong type of visa. He applied for a tourist visa, but really he's coming in to work. If he's coming in to work on a tourist visa, that violates his visa status. And so maybe they, deported him. Maybe it's not a ticket. Maybe it's a 5-year expedited removal. So if that's true, then he's got a deportation order against him. My best advice for him is to not re-enter the U.S. until he's gotten to the bottom of that, all right? Gotten to the bottom of that issue. He might need to file a waiver of his 5-year inadmissibility from expedited removal. Okay? So Wakar, I'm still waiting for you and your question about inadmissibility. Send it over. I love it. Another question I have here comes from Cornelio. Cornelio, thank you for your question. You say, I was deported 2 times. What possibility do I have that my daughter who won here and who is already 26 years old, what possibilities do I have that she could petition for me? So Cornelio, thank you for that question. You're not alone in that question. So the challenge, I need to know a few things in order to help you. One, Cornelio, are you currently here in the U.S.? All right, Cornelio, are you currently here in the U.S.? If not, how long have you been out of the U.S.? Because sometimes a deportation causes a certain amount of inadmissibility, typically 10 years, all right, if you were deported by a judge. If you were deported twice, though, we got to get to the bottom of that. So, Cornelio, my best advice in your situation is, hey, let's request all the records. Let's request all the records. Let's get to the bottom of it, and we can go in much greater depth, all right, and give you better advice about it, all right? All right, Danitza Yanez, I see you there on Instagram. Hello. And Top Drive 190, I see you there on Instagram. Hello, welcome. And let's see, Wakar, I'm going to answer your question, and then I'm going to wrap up for today. All right? So, Wakar, you say, does marriage to a U.S. citizen waive a prior false claim to citizenship for a job? Okay? Does marriage to a U.S. citizen waive prior false claim to citizenship for a job? All right, Wakar, thank you for asking that question. The reality is false claims to U.S. citizenship cause a serious problem because they are not waivable. All right, they are not waivable in a marriage-based case. They are not waivable in family-based cases. Okay? Your follow-up question is, will quitting the job before filing the paperwork help with the case? Okay. False claims to citizenship are tricky. If you make a quote-unquote timely retraction, all right, then yes, you can retract the false claim, and you would need to do that before you file any paperwork with immigration, before you do anything with immigration. So that's possible, but that is a tricky, don't do that on your own, okay? Hire a lawyer to help you do that. Call my office. We would love to help you with that process if you have questions about it. Another thing to say about false claims to citizenship, now that you brought up that topic, is if it was before September 30th of 1996, it doesn't create inadmissibility against you, okay? So if it was for work, if there was a false claim to citizenship for immigration purposes, like you showed a false U.S. citizen birth certificate to the border, even before 1996, that does cause inadmissibility because it's a willful misrepresentation of a material fact. I don't want to get too far into that. But if it is if it's for work purposes, like on the old I-9 form or something like that, and if it was before September 30th of 1996, it will not cause inadmissibility. That's when the law changed. Okay, love it. So I'm getting a question here from Top Drive 190. Top Drive 190 on Instagram, thank you. You say, hi, Otis. My question is, what should someone do if he was denied asylum from immigration but was not sent to court and is not allowed to get an EAD-2? What can I do to reopen the case? Okay, that's tricky. That's tricky. Thank you for asking that. Typically, if you're denied asylum and not sent to court, it means that you still have some kind of other status going. All right, is that the situation in your case? Because if you've got some other status, then the government will say, hey, you're not deportable, and they won't send you to immigration court. Otherwise, the way to get back into immigration court is to refile an asylum application, argue at least withholding of removal or something else there, and sometimes there's a way to directly request to the asylum office that they issue an NTA so that you can fight about your case in court, okay? But that's nuanced, that's complex. Top Drive 190, don't do that on your own. We'd love to help you. Contact our office. We would love to help you with that, okay? The next case, I'm seeing it right now. Let's see. I'm seeing it right now. Nail? Am I saying that right? You've been here on and off since 2004. Your last entry was in 2016. You overstayed due to a domestic violence situation. I filed for a Uvisa in 2017. My biometrics were done in May. Still waiting. Married to a U.S. citizen in 2019. Had a lawyer request FOIAs 2 years ago. Never heard a thing. Why is it taking so long? Okay, first of all, the FOIAs shouldn't have taken more than, I mean, if it was before the pandemic, it shouldn't have taken more than 8 months. Okay, maximum. So if it's been 2 years and you haven't heard about your FOIAs, that's a problem. If it's 2 years and you haven't heard about the Uvisa, nobody hears about a Uvisa in 2 years, right? Uvisas take 10 years. All right, so let's be clear about that. 10 years minimum, okay? And so just be aware of that. Check out my videos on Uvisa processing times, right? There's 150,000 Uvisas pending, and they can only do 10,000 a year. So that's like 15 years, right, that it could take. And so someone told me to wait for the Uvisa because I can't file with my U.S. citizen husband because of my overstay. Okay, that's a different question. If you're married to a U.S. citizen and you entered lawfully, all right, if you entered lawfully, yeah, you might be able to file a straight-up adjustment of status application. Don't rely on what someone told you. Rely on what an immigration lawyer and expert told you, because we can really get to the bottom of your situation and see what we can do to help you. Yeah, if you last entered with a valid entry, all right, and if you're married to a U.S. citizen, hey, let's talk. Let's talk. And maybe we do need to run your FOIAs and study them carefully and figure out what happened. Maybe you have a bar. Maybe you have a 10-year bar even, right, because you overstayed and then left and then re-entered. But as long as you re-entered lawfully, we can file your adjustment of status application. Maybe you need a waiver with it, but we can do that, all right? So I-601, with an adjustment, we can waive any unlawful presence bar that you may have had, nihil, and away we go, applying for a green card, and you don't have to wait all those years for the Uvisa. All right, everybody, thank you all so much for being here with me. That is all the time that I have for today. Anybody listening, if you've got additional questions, if you have your own case or whatever, hey, please pick up the phone. Contact my office. My team is amazing, all right? I love my job because I work with people who are amazing, all right? So my team's amazing. Give us a call. We would love to help you. We are here to help, okay? And if you're here watching me on YouTube, Facebook, Instagram, TikTok, thank you all so much, all right? It's like a beautiful Thursday afternoon, the 17th of February of 2022. Can you believe it? And it's like, thank you so much for being here with me. It's amazing. All right. If it was useful, please hit the notifications bell and the thumbs up on YouTube, because it's like we're trying to grow this thing. And if you could help us with that, hey, I'd really appreciate it. It tells the internet that this was something worthwhile. All right. And if you have a question that I haven't answered or whatever, hey, send us your questions. That's what we're here for. So that's all we have time today, folks. Thank you all so much. My name's Otis Landerholm, Landerholm Immigration, A.P.C, where we fight for your American dream, and I will see you next week on another episode of The Empowered Immigrant Live. Thanks so much. Bye-bye.